This is Up Close. I'm Stephen I. Weiss. We tend to believe that a system of laws is there to protect us. We often believe in the integrity of that system and that it can deliver the justice we expect. The largest verdict for environmental damages in history will forever be quite tainted. Lies, deception, corruption, and more were found to be at the heart of a legal strategy that theoretically won billions of dollars for people harmed by oil pollution. But they might never see a dime of it. Bloomberg Businessweek senior writer Paul Barrett discusses Law of the Jungle, the $19 billion legal battle over oil in the rainforest, and the lawyer who'd stop at nothing to win, now out in paperback. And then, the Orthodox Jewish court system has long explicitly discriminated against women, where no women are judges. Perhaps the greatest symbol of a system designed without women is the Alguna Crisis, in which women are stuck in Orthodox Jewish marriages if their husbands refuse to give them divorces. Susan Aranoff has been an advocate on the issue for 3 decades and is the co-author of The Wed-Locked Agunot, Orthodox Jewish Women Chained to Dead Marriages. But first, whether justice can be found in the jungle with Paul Barrett. We generally believe that the courts are there to call balls and strikes and to rule fairly and to find that, in this case, it's appropriate or inappropriate for someone to receive damages. Right. This is a much more complex situation.
Yeah, absolutely, and I think it's a great place to start because one of the main themes of this book is the degree to which the legal system actually is a good venue for sorting out the kind of very complex social, political, and economic disputes that lies behind this story, namely the question of who was responsible for massive oil contamination in the Amazon in Ecuador.
Let's play back that story. So you have Ecuador in a situation where the government was less than entirely modern, more or less giving oil drilling rights to Texaco in, what was it, the 1960s?
Beginning in the late 60s into the 70s,
yeah.
Yes.
Yeah, and more or less, they just sprayed oil everywhere.
Texaco definitely did not adhere to the kind of standards that we would expect of an oil company operating anywhere, let alone in the United States, today. They did what they could get away with. There were almost no environmental standards in Ecuador. The government did no meaningful regulation. And as a result, there was a lot of contamination. You know, these huge pits of waste oil left exposed to the elements in the rainforest environment, tainted production water, which is the water that comes up with oil when you drill for it, discharged millions and millions of gallons just onto the surface, into the streams and rivers, where people fished, got their drinking water, cleaned their clothes and so forth. So it was a horrendous situation. And then in the early 1990s, when basically Ecuador kicked Texaco out of the country, nationalized the oil industry, the question became, so now what are we going to do about this mess? And Texaco and Ecuador sat down and they came to an agreement, a formal written agreement, whereby Texaco would be responsible for cleaning up 1/3 of these pollution sites. Ecuador, which by now had a national oil company that was taking over the oil fields, would be responsible for 2/3 of the sites. And that division was made according to those fractions because that was the ownership division for the majority of the time that this joint consortium had taken place.
Ultimately, there was a lawsuit by citizens in Ecuador saying the government can't sign away our rights to receive compensation for these damages.
Right.
And what led to, I guess, in theory, the largest verdict in environmental damages lawsuit history?
The largest single company judgment ever. $19 billion is what it initially added up to. And that was the product of an extraordinarily convoluted legal process. American lawyers stepped in to represent Ecuadorian villagers and indigenous tribe members. They initially tried to sue in the United States, saying this is a U.S. oil company, so the courts of the United States should take responsibility for this. The plaintiffs' lawyers fought against Texaco for 9 long years, not over the merits of what had happened in Ecuador, but over where to have the fight. And ultimately, after this long period that took up most of the 1990s, the American courts said, this is Ecuador's problem. The evidence is there, the alleged victims are there. Basically, showed the plaintiffs the door to the courthouse. Texaco thought it had won this tremendous victory, that this problem was over and done with. Texaco, which at that point was being taken over by Chevron, made several miscalculations. Miscalculation number one is they underestimated the staying power and energy of the guy who became the lead plaintiff's lawyer, New York-based attorney named Stephen Donziger.
When you look at this situation, one of the things that you draw out is the real human tragedy here, which is to say whoever's responsible, and to whatever degree financial damages represent that, these are people who were going through a horrible situation where you have, you talk about people who would come covered in oil from walking around and would clean themselves at their doorstep with gasoline, and rub themselves with warm oil to
deal
get
with aches and pains. Kind of almost like symbolic sense. Yes, you're absolutely right that this is a human tragedy, and what really compounded the situation was that once the American Oil Company left and cleaned up its portion of the damage, which is not to say the whole thing. The oil company did not do, did not take
portion that it had in this agreement with the pretty corrupt government of Ecuador.
Well, I guess the degree of corruption would be debatable, but yes, Texaco fulfilled the letter of the agreement rather than saying, look, we've been the ones down here, let's just take responsibility for the whole thing and clean it all up. Texaco leaves, and then pretty much the worst possible thing happened, which is the government of Ecuador, which contractually had agreed to clean up most of this area, did nothing. Moreover, the national oil company took over the oil fields, and in the subsequent 15 years became every bit as bad a polluter, now running their own operations, as the foreign oil company had been. And this is very carefully documented as well. So the environmental harm was compounded, the human damages, whatever health harm would be suffered by people who were living near this industrial area was compounded. And meanwhile, the lawsuit grinds on, and no actual compensation or help, establishment of medical clinics is flowing to the victims in Ecuador.
Ultimately, this story keeps revolving around this basic question of what do you believe justice is, and where do you believe you're going to find it, and very frequently are you going to believe me or your lying eyes around who's in the right, who's in the wrong, who deserves compensation, how much compensation do they deserve, and what kind of justice is really available.
Right. You've outlined many of the key themes in the book, and one of the central questions really is a courtroom where there are going to be very particular, and in the case of a pollution dispute, scientific standards for proving who did what. In this situation, you have a 20-year period where the U.S. oil company is operating. Then basically another 20-year period where the Ecuadorian oil company is dominating. And now you go back and you look at all this damage over all this time. You say, whose oil is whose? Texaco claims, well, we cleaned up this portion. And the Ecuadorians say, no, you didn't. And then the plaintiff's lawyers say, no one cleaned up anything, but we only want to hold Texaco responsible, not Ecuador, because that's a much more appealing lawsuit. The little people versus the big oil company, as opposed to the little people against their own government, who, by the way, is never taking care of their own people.
Right, and who could pretty much write off a judgment against them because they own the justice system.
Exactly. Right. And so you've got that question: is the courthouse actually a good venue for sorting this out? Then you have yet another layer of complexity, which is, do the ends justify the means? Do the means that the plaintiff's lawyers chose, once this case got sent back to Ecuador, and once it was operating in the undebatably murky confines of the Ecuadorian legal system, was it right in the name of justice for the plaintiff's lawyers to cut corners? Because as it turned out, they were fabricating evidence, they were coercing judges and court experts, cutting all kinds of corners, which led them to this huge seeming victory in Ecuador, with the Ecuadorian courts saying, okay, we hold the oil company completely responsible, we look away from what our own government did. Oil company hand over all these billions of dollars. Well, what kind of victory is that? In fact, it has turned out to be an empty victory because the oil company refuses to pay up. The oil company comes back to the United States, now it's under the aegis of Chevron, starts a new legal battle, this time against the plaintiffs' lawyers. And the plaintiffs' lawyers are sued for their corruption of the Ecuadorian court system, and we end up now 22 years down the road from when the legal fighting started, almost 40 years from when the whole story began, and there actually has been zero justice.
Let's talk about the efforts of this lawyer, Stephen Donziger, who was the plaintiff's lawyer, who talked a big game about being there for the people. And I guess in a way, right, he devoted 20 years of his life working at a pretty low salary for a lawyer of his type, to trying to get something for these people. But he broke every rule in the book.
Well, that's what a federal judge in New York determined in 2014, because Chevron sued Donziger under the U.S. anti-racketeering laws, and a federal judge ruled that Donziger's lawsuit had basically devolved into an extortion racket akin to what you'd expect from the mafia. Right. And now the seeming victory in Ecuador is tainted by this U.S. finding. And a guy who I think probably started out with good intentions. Sure, maybe there was a big ego. Sure, maybe he wanted to make a big name for himself, or maybe even make some money. But there's not necessarily anything wrong with those things. Lawyers have those mixed motives all the time.
Nobody talks about lawyers generally as the nicest people in the world.
Well, we don't want to generalize about lawyers, but certainly...
You happen to be one. Right?
Well, I happen to be one, in a technical sense anyway. But there's nothing wrong with wanting to be paid for your hard work. And as you said, along the way, it's not as if he was becoming a rich man by pursuing this case. He wasn't doing it for free because he raised a lot of money along the way from outside investors, yet another strange layer of the case. Basically speculators who bought pieces of the ultimate outcome in exchange for investing in the case. And he actually raised some tens of millions of dollars that way. So it's not as if it was David with absolutely no tools at his disposal against Goliath. It was David and Goliath, but David had something of a war chest himself. Okay. But the problem was that the oil company said, we will not recognize this corrupt Ecuadorian verdict as we see it. We don't have assets in this country anymore, so there's nothing for you to seize there. The oil company cleverly comes back to the United States, sues Donziger in this country, and they get a verdict. So they now have this a 500-page judgment from a U.S. court in New York that says the Ecuadorian verdict was a sham. The Ecuadorians
You can't collect anywhere in the United States.
Correct. The Ecuadorians say, well, we're going to find a place to collect this. So they begin legal actions in Canada, Argentina, and Brazil, which are going on even as we sit here today. And Donziger, I got an email from Donziger just this morning in which he is continuing the fight as he sees it. He sees it as a righteous fight. The oil company sees it as a corrupt fight. I would say that someplace in the middle, something would be hard to argue with is that it became very tainted, that the overtone of corruption has very badly undermined the justice of his cause. But meanwhile, he denies he's a racketeer, and he's continuing to push in Canada. And they're going to have a trial in Canada now, in Ottawa, over the legitimacy of the Ecuadorian verdict. And it's going to be Chevron invoking the view of the American courts, which is it's all corruption and a sham. Donziger and his allies saying, as far as the sovereign state of Ecuador is concerned, we have a legitimate judgment. We want to start selling Chevron assets in Canada to pay that judgment. So the fight continues. It goes on and on and on. And the question is does this make any sense? Or should there have been long ago some type of politically brokered compromise? Without all the flags waving and the trumpets blaring and discussion of justice and bringing indigenous tribe members in tribal dress to the courthouse steps in New York, all of that was tremendous theater for a long time. But it doesn't always lead to justice, and this case is not unique in that regard. Often we spend a lot more time marshaling the celebrities and shaking fists and having demonstrations, filing lawsuits, nothing gets done.
That ultimate question of where is the justice here leads you down a number of thorny paths. And one of them is where we've seen many complaints about the U.S. justice system as being inequitable and various other problems with it. But boy, it's a lot better than Ecuador.
Well, that's true.
Yeah.
The Ecuadorian system is something that, to the eyes, I think, of an American lawyer, and certainly the eyes of an American civilian, would be unrecognizable. You have a degree of interaction between the judges and the warring lawyers. They're getting together in the evenings and drinking, exchanging information outside the courthouse. In the end, the federal judge in New York, who took a close look at what happened in Ecuador, determined that the very judgment itself, a 188-page judgment in Ecuador by the Ecuadorian trial judge, had been ghostwritten for that judge, who only signed his name to it, by lawyers on the plaintiff's side. So that gives you a sense of the strangeness of what's going on down there. And sad to say, that while I wouldn't want to generalize all around the world, the legal systems of a lot of other countries, particularly less developed countries, where they haven't had a sense of the rule of law for all that long, often have that type of corruption. So yes, there are tremendous flaws in this country, delays, expenses, and so forth. But in a comparison, we have sort of a beacon of rationality here compared to what goes on in a lot of other countries.
But at the same time, there's this other side to that argument where people say, well, this is the only chink in the armor that we found of international corporations with untold billions of dollars of assets. And there simply is no other way to win in the United States or in Ecuador or anywhere else, because they can just keep cutting checks wherever they want to. And in a sense, there's Chevron, Texaco, when they first got to Ecuador, there's not even a question about what kinds of payouts and what have you was the government involved in to give these rights to a certain oil company, or to what degree was the government back then the kind of place where you just money changed hands and various things. Nobody's even legislating that at the beginning, and we're only looking at this at the end.
You're certainly correct that many people do see this kind of long shot lawsuit, a lawsuit filed in the United States about events that took place at Great Remove in Latin America many years earlier, as the only way, the chink in the armor, as you said. Look, it may not be perfect, the argument goes, and maybe in the end, corners do get cut. Maybe the evidence isn't marshaled according to the way we learn about it at Harvard Law School. But we do the best we can, and as you say, the other guys are very wealthy, very powerful, and this is our only shot. That is kind of the Robin Hood justification. Yeah, being an outlaw in the woods, not ideal, but there's really no way to hold the sheriff of Nottingham responsible unless you kind of use guerrilla tactics. I'd say actually that makes a whole lot of sense for Robin Hood, who lived as an outlaw and who basically, if you look at that legend, the lesson there is that a layperson has to make up their own sense of right and wrong. But a court is different. If you wanted to be Robin Hood in Ecuador and advocate politically for the government of Ecuador, which could have taken responsibility for this situation all the way back at the beginning, to remedy the situation for their own people, and you wanted to lead a march on the Ecuadorian capital in Quito and say to the national legislature, devote some small percentage of your oil revenues to cleaning up what's been done in the past. Texaco is responsible, national oil companies responsible, let's get it cleaned up. There would be a lot to say for that. But when you try to use the courthouse, where you have this kind of special effect, the idea of a court, at least the American idea, is that the court has a leveling effect. Party A and Party B, no matter how powerful they are outside the courthouse, in the courthouse they are equals. And so here the poor, disadvantaged people can actually hold the big corporation to account. That's the theory. But if you're going to use that approach, if you're going to invoke the tradition of the American civil rights movement, women's rights movement, where lawyers in nice coats and ties go into court and argue for justice, you actually have to follow the rules of the court. You get the advantages of litigation, scientifically marshaled evidence, an impartial judge, and so forth. With that advantage comes a set of obligations. And sadly, the plaintiff's lawyers in this case lost sight of that. They were operating in Ecuador. They thought we're going to play by Ecuadorian rules, and they won in Ecuador. By Ecuadorian standards, they won. As far as the sovereign state of Ecuador is concerned, the plaintiffs are right, the oil company's wrong, billions of dollars should change hands. But in a practical matter, the oil company thumbs their nose at that and says, we have no assets here, come and chase us someplace else. And when you look at what happened in Ecuador through the prism of the United States legal system, it doesn't hold up. And now we'll see what happens in Canada.
So if you want that judgment recognized in the United States,
you got to follow the rules.
You have to export your ethics with you when you take everything alongside,
exactly.
right? And then at the same, there's still this, the Foreign Corrupt Practices Act, something that we've seen used, I think recently with Walmart and other firms, but if you talk to people in international business, you know that these things happen a lot. There are all these little bits of corruption happening all over the world.
That's probably true.
And there doesn't seem to be recourse. And there seems to be this movement that says there's a larger justice here. There's a larger justice at play here. And that's ultimately what the debate ends up being, is between people upholding this very rational, very reasoned U.S. law, but that we know can be, in the end, highly inequitable in tilting towards those with great amount of funds.
Law doesn't necessarily produce justice. Law produces procedures and rules and regulations, which, if they're enforced, may lead to justice. But it doesn't lead directly to justice. You've got to prove your case. You can't just say, look at me, I say I'm right, give me what I want. That's not the way the legal system works.
Right, and then you have there's this community that ultimately just doesn't care. Like, you have some of the advocates in this case. You had celebrities like Sting and his wife, Trudy Styler, who's like a model and what have you. And this larger environmental movement where some people are still with Stephen Donziger. Some people are still saying, there's this larger justice here.
I think they ultimately are so enamored of the Robin Hood scenario that if you have a confrontation between poor people who live in the jungle and who live in bereft oil towns in rural Ecuador, and they are facing off against a big corporation, and there is pollution on the ground, which is true. People have been harmed, the environment has been harmed. We don't really need to know the details. You give me Indians, oil on the ground, and a big American oil company, I know the story. And a big part of the message of my book is, well, you don't know the story. You need to actually hear the whole story. You need to hear how the oil got there, the multiple parties that were responsible for putting it there. You even need to hear, for example, how most of those poor people ended up living so close to the industrial operations, because that's not even so straightforward. Nothing is so straightforward. For example, the vast majority of the victims here are not indigenous tribe members. They are mestizo, Hispanic-descended transplants to the oil region who were literally shipped there by the government simultaneously with the invitation to the oil industry to develop this area. The Ecuadorian government moved people
in harm's way.
In harm's way, gave them free land because they wanted to develop the Amazonian jungle. Now, that's Ecuador's business if they have that social policy, but that social policy had a huge side effect. That resulted in, when the roads got paved and the oil got drilled, people were living on the roads, living near the oil operations. And it's not, of course, it's not the local people's fault. They were promised free farmland and a way to make a living, and they had been living in some crowded slum someplace, so they took the chance. But it was, the oil company didn't invite them to live there. So it's a very complex story. By the same token, you alluded earlier to, the possibility of payoffs by the oil company to the Ecuadorian government. Yes, I'm sure there was that kind of thing at the margin. However, it's also important to emphasize that the Ecuadorian government actually went into this with its eyes open. It negotiated and renegotiated treaties, and over time, 90% of the revenue that was derived from oil operations while Texaco was there, a total of some 23 or 24 billion dollars. 90% of that stayed in Ecuador. That is simply how the international oil industry works. It's not actually the way, perhaps, I don't want to put words in his mouth, Sting may think it operates. A big oil company doesn't go in and literally take all the oil out and all the profits with
and then
it.
leave a few coins and walk away.
That's actually not the way it works. The oil belonged in the large part to the Ecuadorians. The Ecuadorians sold the oil. The oil that belonged to Texaco was taxed at very, very high rates, resulting in a huge amount of money staying in Ecuador, all of which is fine and the way it's supposed to work. I mean, roads got paved, villages got electricity, many thousands and thousands of people, both people doing industrial jobs and people doing white-collar jobs in Quito, were employed because the oil industry came to Ecuador in the 1970s. The country went from one of the poorest countries in Latin America to still not a well-off country, but a member of OPEC and involved in international commerce, and a middle class developed that hadn't been there before. Again, that doesn't justify pollution, but it fills in the story. You can perhaps begin to see why Ecuadorian elite society in Quito would have been so tolerant of the oil company, or at least look away from what the oil company was doing, since all of Ecuadorian society was actually benefiting tremendously from the presence of the industry. And the poorest of the poor, of course, were the ones who were at a disadvantage.
And what you're left with is a situation where Texaco Chevron has spent, I mean, you pointed to, I think, just for one law firm, that they paid towards the end something like $400 million
They've spent hundreds of millions of dollars over time, possibly over 20 plus years, $1 billion, possibly.
Right. If you include staff time and this and that and the other thing.
And that's an extraordinary amount of money, way more than it would actually take to do a whole lot of good in Ecuador. And it's a terrible paradox that all of these resources have been expended in legal combat when a portion of those that money could have done a lot of good on the ground.
And a portion of that money in a settlement offer from Texaco Chevron in the 1990s would have ended everything in all likelihood. It would have stopped it cold just said, all right, here's $100 million.
That's right.
And
the case could have been settled probably even for less than that. Way early in the case, in the mid-1990s, the plaintiffs made a settlement proposal. They actually did it down to the dollar, and it was some $141 million was their opening bid. And based on my experience covering this kind of litigation, you know, a case, when you start there, you often end up at less than 50%, and the case gets settled that way. The lawyers take their cut, and for better or for worse, it's all done. So yes, you're absolutely right. The company should not have misbehaved in the first place. The company should have resolved the legal dispute once it evolved into a legal dispute in the early 1990s, rather than fighting a decade-long battle over jurisdiction and basically just trying to wear the other side out, assuming that they would, once worn out in this country, they would never resurface in Ecuador. And even now, there should be some way to come to a compromise. The sad thing is the would-be representatives of the little guy and justice themselves, in a different sense, polluted the case, in this case with white-collar corruption and pollution. And so now we're left with this morass and this very, very serious question about whether this kind of incredibly complex challenge is best addressed in a legal context, or maybe we need to say, you know what, there's a lot of dirty hands here, so to speak. A lot of people contributed to this problem. A lot of people are suffering. What's the price tag? How can we get to work, you know, cleaning the situation up?
Right, but there is no international body to create that kind of deal. And of course, a U.S. government is largely paid for by some of these kinds of corporations to begin with. But then ultimately there's this question of, we have this idea in the United States, we have a reasonably good justice system, and it's very much everything's disclosed, everything is transparent. But then this thorny problem happens when we interact with rival courts, right? Or not with rival courts, but with courts outside this country, courts outside these immediate jurisdictions.
Well, these questions of what to make of the results of foreign judgments particularly when foreign courts sock American corporations with huge multi-billion-dollar judgments, is becoming a more common problem. And it is one that raises all kinds of important tensions, because we want to respect the sovereign judicial systems of other countries. But on the other hand, if it's just a shakedown operation, well, that doesn't deserve our respect.
All right, well, we'll find out what does deserve our respect. Paul Barrett, thank you for joining us.
My pleasure, thanks.
And now, the Alguna Crisis with one of the most prominent activists on the issue, Susan Aranoff. When we hear about the situation of Orthodox women chained to marriages, this is where they have that Orthodox law states that a husband must willingly give a document of divorce to his wife to make her divorced, and until that happens, the divorce won't be recognized by the overwhelming majority of Orthodox rabbis. And what you're cataloging here is some of the horror stories that can result when there's that much power belonging to one man. What are some of the worst examples that you've seen result from this?
The worst examples, I suppose, are those where there's been pedophilia and extreme cases of domestic violence. I say extreme because many people say that domestic violence, that is some physical abuse, is not as damaging in the long term as emotional and psychological abuse. But in the worst cases, it's absolutely hair-raising. And the most extreme case that's contained in the book is the Zitrenbaum case, where Belima Zitrenbaum's husband was convicted of attempting to murder her, and yet, even though he was jailed for that crime, she was still married to him and still needed a get. You can't get more extreme than that. And then the second most, not second in terms of how horrifying, is the cases that we've had where rabbis have insisted that women drop charges of admitted pedophilia on the part of their husbands in order to obtain the get. The husband was demanding that the charges be suppressed, or else he would not grant a get. And the rabbis took the position that it was more important for the woman to get the get than to report this crime. And the case that we describe in the book is not unique. There are other cases like it.
And why is there that power, that ability to keep women in marriages who are in such extremely inappropriate marriages?
Impossible
marriages, yeah.
Yes. Well, it stems from the way Orthodox Jewish marriage is structured. I'm not going to speak about Reform and Conservative, although there are some parallels, but the issue is more or less resolved in those streams of Judaism. The marriage is structured as an acquisition, where the husband is acquiring a wife. And like any other acquisition, the acquirer is the only one who can divest him or herself of the object that is acquired. Now, it's not the same as acquiring a car or a cow, or if we go back to biblical text, a slave. The woman has far more rights, and the husband has obligations of a higher level toward his wife. But the bottom line is that the only one who can sever that relationship is the acquirer, the husband. And even under very dire conditions, his control over his wife's basically sexuality, she can leave him. No Beit Din would force a woman, no rabbinical court, Beit Din, would force a woman to remain with a husband that she despises, but they won't release her in terms of her ability to remarry and have children until the husband willingly releases her.
And now your personal story and that of Rivka Hout, your co-author who passed away last year, is of pretty much volunteering great quantities of your lives to help women in these situations where they are stuck in these marriages that they cannot end. And to do that, you had to learn a great amount of Talmud. You had to do a great amount of study around laws of divorce at both the civil level and at the religious level. And one of the things that's amazing that even at the end of that, even at the end of those decades of work, all you are is an advocate, right? On the other end, there's this all-male Beit Din system, an all-male rabbinic world in the Orthodox world, where these laws are decided. And it's an amazing thing in America, where all male juries were outlawed in the 60s, that there really is there's no woman in control, in any position of control or authority in this entire situation.
Well, that's correct, although there has been a lot of progress in the last few decades with regard to women's status in the world of Jewish learning. There are women who I think are acknowledged as having attained the levels of scholarship that would qualify them as rabbis or religious court judges. But yes, you're right, there's a gender ceiling, and even if they have that knowledge, they can't officially serve on those panels. Nevertheless, having the knowledge is crucial, because we can at least hold the rabbis' feet to the fire. It took us time to learn all of that naturally, but we've hit up against the stone wall. I could even say that if some of these very highly qualified women were on these rabbinic panels, I'm not sure the result would be different, because there are some rabbis, male rabbis, who have taken the position that these women can be freed, but the overwhelming majority of establishment Orthodox rabbis have rejected those approaches. And it's happened twice. Once was in the case of the late and revered Rabbi Rachman, who set up a Beit Din to free women. And right now, as we speak, that whole, as the late Yogi Berra, who just passed away a couple of days ago, said, it's deja vu all over again. Rabbi Simcha Krauss, is attempting to free women from these horrible marriages, and he's beginning to be attacked by others.
Right, and so to lay out the groundwork there, you've got this hard and fast rule around a husband willingly handing this document over to his wife as the core requirement for severing an Orthodox Jewish marriage. And then there are some workarounds there. There are some ways that some rabbis have come up with detours around that process, where you have, for example, different ways of appointing the rabbis involved. You have different ways of saying, well, maybe, as we see in the Catholic Church with some frequency, maybe this marriage wasn't really legitimate in the first place for a variety of reasons. What is the overall situation there? What are the ways that we've come up with that exist for generating that workaround, and why aren't they working in all cases?
Well, some of them are working. It's important to make one distinction. One is something that you refer to, which is to say that in fact, technically, the marriage never occurred. The second.
And what are some reasons why that might?
So again, we can bifurcate that. One is if there was some defect in the ceremony. For example, the witnesses weren't qualified. And without the witness, if the witnesses are not qualified, technically, according to halakha, the marriage never occurred. The couple might cohabit, but the marriage was never properly created. And it doesn't have to be, there's no requirement for divorce because they were never married. That is the easier way, because it's factually much easier to determine whether the witnesses were qualified. The question of qualification is if there was too close a familial relationship, in which case they were an interested party, or if the person is not religiously observant according to Orthodox requirements, then they don't qualify as a witness. When that happens, the bride is lucky, and she can escape that marriage. And as I said, factually, we can check the background of the witnesses. Or another one would be if the ring, which is sort of the consideration in the transaction, if the ring didn't belong to the groom, if there was some defect in the ring, those are factual things that can be determined after the ceremony. The second way to establish that there was an error or mistake is if there's some defect in either party. In this case, we're concerned only with the groom, because it's the wife who's trying to assert that there's an imperfection in the marriage. If the groom had some major defect that was so grave that a typical woman would not have agreed to marriage had she known of this defect, then likewise we can say that the marriage never occurred, because you have to give informed consent, and if you're uninformed about a major aspect of the marriage, your consent was not informed. Some examples of that are if the husband is impotent, in which case the rabbis will void is wrong, will declare that the marriage was void ab initio, never happened, because that's a major element in marriage. if the husband, also I'm giving you the cases that are in the rabbinic literature, if the husband is homosexual, because in a very well-known response by Rabbi Moshe Feinstein, a very widely respected Orthodox rabbi, no, the average woman would not willingly consent to marry a homosexual. And a third one is, very oddly, if the husband has epilepsy, which I think at the time that this entered into the literature was probably considered such a mystical, scary type of disease that if the woman had known, she never would have married him. And it's important to know that the husband does not need to have known about it. So there's no question of malice here on the part of the husband or deliberate deceit. It just turns out that there was this defect. I thought of another one just now. If the husband had a verifiable record of some sort of insanity prior to the marriage. It's another famous response in Rabbi Feinstein, where the husband had a history of being institutionalized. He had a period of normalcy where he appeared normal and then reverted to this mental illness. So in those cases, the wife can say, wow, if I had known, I would never would have consented.
But in practice, Rabbi Moshe Feinstein, who was considered by and large the greatest Orthodox Jewish legal decisive of the 20th century.
Well, there's some dispute about that,
but by and large,
among the greats, yes.
But by and large, pretty much everyone, until you get to the extreme ultra-Orthodox enclavists, would say this man is someone they endeavor to follow.
Well, let me just add, it was not without controversy. When he published those responsa, he was criticized. But yes, you're right. He's certainly considered a great of the 20th century.
In his practical application of these, you say he dissolved marriages where there was domestic violence. He used much more real-world problems to dissolve marriages.
Well, I don't want to overstate Rabbi Feinstein's position. The cases that are in the literature are the ones that I've listed. I'm not quite sure that he would have dissolved a marriage based on domestic violence. There are some references in his responsa about a husband not even having a concept of what a proper marriage is, which I think would cover that kind of thing. And it's important to note, not from theory but from reality, that almost all, I'll say all of the domestic violence cases that we deal with, the domestic violence began almost immediately. So because here's where the difference between the technical voiding of a marriage in terms of witnesses or some defect in the ceremony and those based on insanity and so on. It's harder to prove. We're always asking the women that we deal with, do you know if he was taking medication for some mental illness before? Can you find the prescriptions? Is there a doctor who would attest to that? Which of course they won't because it's confidential. The minute you get into a defect in the husband, proving it becomes more difficult. So domestic violence, if you can prove there was a record of previous domestic violence, we've had cases like that, I think that would be an easier case. We had a case where a woman, an agunah, managed to find her recalcitrant husband's first wife. And that woman had submitted a record of his domestic violence to the Beit Din. So we had his history of domestic violence prior to marrying the second woman, and we were able to make the case that he was an abusive person, and we consider that a personality disorder, prior to the marriage. It's harder if you can't find those records. I personally feel that domestic violence is grounds for freeing a woman, but now I'm saying something different. I'm saying even if you can prove that it preceded the marriage, even if you want to assume that he became domestically violent only after the marriage, that the woman should be freed.
But overall, then, what one's left with is a situation where even the most liberal Orthodox applications, which are disregarded by a great many rabbis to the right of them, that try to say, we're going to end this marriage on the basis of either this man being horrible in any number of ways, or him being defective or what have you in a variety of ways.
Let me add, in a way that the average woman would never willingly accept.
Right.
So it's a serious defect.
One's left with an extremely high bar, right? Because even among the most liberal applications, they're demanding basically that the husband be either horrible or defective in certain very obvious, very blatant ways, as opposed to saying simply, this marriage is going over, or he's just not a very good man. He's not good. He's not a good husband and father, and on that basis, saying that simply she deserves to be out of this marriage, and therefore we're going to get her out of this marriage. So one's left with a situation where the vast majority of divorces are still left with the man almost entirely in control.
The man is in control, but in those kinds of more normal cases that you've described, they rarely become get cases. They rarely become agunah cases. The cases that we're dealing with, these men are dysfunctional across the board. There's always, almost always anger and vengefulness at the time of divorce, a feeling of rejection. But people who are in the normal psychological range eventually accept it and move on with their lives. The men that we're dealing with, so we're talking about a small set. So what you said, a guy who's just not a good father, he's not going to withhold the get for 10 years.
But the thing is,
but you're right in theory. Right. The husband's in control.
But the thing is that to me just says we've set a very high bar for what we call an agunah, right? That we call a woman who's chained to her marriage for 6 months, a year and a half. At some point we start the clock and we say, all right, this woman's an agunah. But there are divorce cases that drag out for, even if they drag out for a couple of months, longer than they should, longer than they would if the parties were relatively equal, under a relatively equal
playing field.
Yeah, that we would have, we would have. You can't even begin to count how many civil divorces or how many relatively, I mean civil in the
Formal
decency
legals?
sense.
Oh,
in the decency sense.
Okay.
How many marriages simply have, somewhat altered custody terms, some tens of thousands of dollars of difference in financial settlements, because the husband could have said, well, I can hold on for a couple more months, and I won't, if I get another 30 grand, if I get another, if I get to have the kids split more with me on the holidays, things like that.
I hear what you're saying, but the reality doesn't match with that. The reality is that they're not, it's rare that the husband is just holding out for some I can't say relatively small, because better visitation or custody is very important, but I can't think of any cases that we've had where I would describe the husband as someone who's just angling for a little bit better. It's extreme. It's always extreme.
Right, but what I'm wondering about is the whole structure of Orthodox Jewish divorce, where you say, all right, there are these extreme cases that nearly everybody says, wow, that's really horrible. But there's a systematic
correct
dismissal of women and their right and equality within the Jewish divorce structure overall.
Correct. You're absolutely right. The playing field is not level, and the women enter into this negotiation of dissolving this marriage at a terrific disadvantage. So for those men who are inclined to be abusive, it's a weapon in their hands. You're absolutely right. And it could be smaller or larger. It could be the small things that you've discussed, and they don't come to us because the woman ends up conceding just to end it all. So to quantify how much women are giving up in terms of money and other rights, it's infinite. I really don't know how to do that.
Right. You do try to quantify how many women are agunot as you classify them. What is the classification there? At what point does a woman become an agunah?
There's debate about that too. In Israel, the former chief or head of the rabbinical court in Jerusalem, Rabbi Ben Dahan, who's now a member of parliament, for a number of years would broadcast numbers like there are only 49 agunot in Israel, there are only 52, on the grounds that as long as the woman was in negotiations, and translation, as long as it was still the process of extortion was going on, she's not an agunah, she's just bargaining. So our definition of an agunah is closer to what you've been sort of implying, which is any time that the husband is using the get as a bargaining chip to extort unfair concessions, she's an agunah. So based on that definition, there are probably tens of thousands of agunot in Israel because there is no civil divorce there. So every woman, whether she's Orthodox or not, has to go through that process. And I would say based on our experience here in the United States, there are probably thousands because we get about, when we were really in the prime of our activity as Aguna Incorporated or Aguna International, 70 to 100 calls per year. We interviewed rabbinical courts, and each one consistently said about 20% of the cases are problematic. The Beit Din of America deals with about 500 a year, so they're producing 100 a year. And we know that the number of agunah cases that are resolved each year are perhaps 15 or 20 or 30. So every year there's a hangover of 70 new agunot. So there are thousands. Some of them just give up, they just sort of fade into the sunset. And either they leave the Orthodox community or they go on with their lives, never marrying again, never having children. So the data is very hard to come by, but I think we can say there are thousands in the United States. By the way, we've had cases from Latin America and Europe as well, and tens of thousands in Israel.
Right. And one response you might see to that is for someone to say, well, you've bought into this extremely patriarchal structure. And there are outs, in a sense, if you go into a less patriarchal structure, if you go to a conservative rabbi. Why is that not a decent solution? Why is that not a reasonable solution? To say to women that community just isn't equal for you, and maybe you shouldn't be there in the first place.
So there are two problems with that from the point of view of the agunah. One is these women are Orthodox, you're right, and in a sense you can say it's their own piety that traps them, because if they moved over to the conservative movement, they could have their marriage voided and they could have a new life in the conservative movement. They're not, they're Orthodox. So yes, in a sense they're buying into that system. But beyond their own personal responsibility for remaining in that system, by the time these women reach this very difficult moment in their life, their children are already educated in that system, and in many cases would be alienated, would actually turn against their mother if she left that way of life. She would certainly risk custody. She might even risk some custody problems in a civil court, because there's a question of when children are brought up in a certain milieu and in a certain school system, can one spouse demand that these children have a radically different lifestyle? That's evolving. Years ago, that was pretty firm. You couldn't, and it would be very often that husbands who didn't want to pay for Hebrew day school would say, and who became less observant would say, I don't want to keep paying for that. I don't follow that way of life. And judges would say, this couple was married under these assumptions, and those children have been in that school system for X number of years, and you're obligated. You cannot disrupt the child's life. So here's this woman who, I'm putting aside the civil aspect because I think that's evolving, but who stands a chance of losing all her friends, even having her parents ostracize her, losing her children's affection and respect in order to go on with her life in another segment of the Jewish community. So it's very complicated.
But at the same time, your proposed solution for women is to somewhat go against the grain of that community. And you basically say, women should not be going to these rabbinical courts, these batei din, for their divorce proceedings. They should simply be going to civil courts in the jurisdiction that's appropriate. And then at the end of that, part of that divorce settlement should be that they need to get, that the husband needs to supply the get as part of the religious court proceedings, and just leave only the get to that religious court proceeding.
Well, we're advising the women to do that, but we're doing more than that. We're saying that the community should get behind this. I don't want the woman to have to be the one who is ostracized because she's taken that stand. The community has to stand up and recognize that the batei din are dangerous for women and children, and to take a stand that they want these matters settled in the secular courts. Now, let me say that's not a foolproof resolution, because at that point, if the husband refuses to give a get, she's still going to have the same problem. But it would move the ball a little bit down the field if the community and the rabbinate would say, we're not going to deal with these issues. It cannot be dealt with fairly in a Beit Din.
Right, and also though, but as part of a divorce settlement, if that's part of the divorce settlement, and then you don't fulfill your obligations of the divorce settlement, presumably things that reopens the divorce and presents real penalties in financial terms and other terms for the father.
You mean if the civil divorce stipulates that he's supposed to give, well, that's problematic halachically, because if a civil court orders, you have to be very careful with that. If a civil court orders the get, then that represents coercion, and the get will not be kosher, it will not be accepted, because, as you've said several times, it has to be given by the husband of his own free will. If, on the other hand, the husband voluntarily, quotes, through his attorney, stipulates that as part of the divorce he's going to give the get, yes, that becomes enforceable. However, there will be rabbis, and not necessarily on the extreme right, who will say that there may have been some form of coercion involved, and that as it was pressure, fear on the part of the husband that the judge wouldn't look favorably upon him declining to stipulate that he would give the get. There is a New York State get law which kind of embodies what you've been talking about. There are two get laws, and many people don't understand the distinction. The first get law, which was passed in the 1980s, says that a party to a divorce has to sign a declaration that they've removed all barriers to remarriage, which is code for the get. Today it could be code also for Sharia, but at the time it was drafted, the target community was the get. It's New York State only that has this law. So if the husband was the plaintiff, in order for him to complete his civil divorce, he would have to sign, I've removed all barriers, meaning I gave the get. If the wife was the plaintiff, which is in 99% of the difficult cases, that law was meaningless, because of course she would sign, I've removed all barriers in my power, because nothing's in her power. And she would get a civil divorce without the get. The second get law in New York allows the judge to take into consideration the refusal to remove barriers to remarriage. A good chunk of the Orthodox rabbinate accepts that as compatible with halakha. There are rabbis who say that that second state get law, New York State get law, is incompatible, that it represents coercion, because the husband will be thinking, if I don't give the get, my wife comes in and says she wants better support, she wants more assets, I better give the get or else I stand to lose some money. And many rabbis, not the majority, but many rabbis say that's invalid coercion. So to say that we would structure the civil proceedings to include the get, the husband would have to volunteer that in most cases. It couldn't be part of the civil package. That in itself would not be a solution. It would help. I'm in favor of trying anything. But I can see where there would be objections by many rabbis.
And then the situation now where there is this Beit Din that's been established by several rabbis, and supported by perhaps hundreds of rabbis, but then also opposed by a number of extremely prominent rabbis who are to the right of them, to try to remove some of these barriers. What is your understanding of how that has come through, and to what degree does it solve the problem, and to what degree are the objections to it legitimate or illegitimate?
Well, the way they're operating, as I understand, and I won't say all I know is what I read in the papers. I know more than that. But I've read their response to their rulings on the website. On their website, it's the International Beit Din, and the leading rabbi there is Rabbi Krauss. Close associate is Rabbi Warburg. I think their approach is viable, but they're being attacked in the same way that Rabbi Rappman was attacked 15 years ago. And the crux of the challenge is whether or not absolutely intolerable and immoral behavior after the marriage is grounds for freeing a woman. It's the same question all over again. There's no objection to if it's an invalid witness or the ring wasn't appropriate or whatever. The question is, if you cannot airtight prove that the husband had this defect prior to the marriage, is pedophilia, is domestic violence, is infecting your wife with AIDS, grounds for freeing the woman. And these are not theoretical questions. So we've had cases with sexually transmitted diseases where clearly the husband was having sexual relations outside the marriage, and the vast majority of rabbis said that's not grounds. She got herpes, but that's not grounds. She lives in fear that he'll infect her with AIDS, but that's not grounds. She can leave him, but she can't get a get. So Rabbi Krauss is under attack, and it's up to the community. The community has to respond to this situation. If 20% of the community stands behind Rabbi Krauss and says, we will welcome these women as spouses for our sons after their marriage was dissolved by Rabbi Krauss, then that woman finds a home in 20% of the community. Let it not be 100%. Let it be 20%.
And then finally, there's a suggestion that you have that the situation here has gotten less liberal, has gotten less welcoming, has gotten less open towards women, and become more restrictive in the sense that the approach that you're pushing for of having basically a larger civil divorce proceeding and then a rabbinical court being used only for get. You say that large rabbinical courts were using that 20 years ago, but aren't today.
Yes, well, the Beit Din of America, which processes more gitin, more religious divorces than any Beit Din in the United States, up until the 1990s, I know from interviews with leading rabbis from that Beit Din that they actually encouraged people to settle all of the ancillary matters, child custody, visitation, alimony, marital assets, settle all that in the civil court and come to the Beit Din of America only for the get, which is ideal as far as I'm concerned, although it still has the risk that the husband will withhold the get. And certainly it's better in the sense that the woman is not censured or criticized for having gone to civil court. Today, in the 21st century, the Beit Din of America, I'm not saying that they'll refuse to handle such a case, but they don't look favorably upon women going to civil court to settle all of those ancillary matters. And if the husband insists on reopening all those matters, the Beit Din of America will stand behind him. And that's true certainly of all the rabbinical courts to the right of the Beit Din of America. In fact, we've had cases like that, where the Beit Din refused to apply any sort of pressure to the husband because the woman refused to relitigate all matters. Let me add that actually rabbinical courts do not have final jurisdiction over matters concerning children. The civil courts retain jurisdiction over the welfare of children, and if the wife can demonstrate in court that a ruling by the rabbinical court was harmful to the welfare of the children, the civil court will reverse it. But that could cost hundreds of thousands of dollars. Very difficult.
We'll see how this situation continues to resolve towards perhaps improving the welfare of others, but perhaps not. Susan Aranoff, thank you for joining us.
Thank you.
That's all for this week's episode of Up Close. A reminder, you can also listen to an audio-only version of this program free as a podcast, available on iTunes and your favorite podcast player.